Welcome back to my video series examining Akilah Obviously's copyright infringement case against Sargon of Akkad. Hopefully you've already watched my first two videos doing a quick introduction to this video series and the relevant section of Copyright Act of 1976 regarding fair use and how the four factors are to be evaluated in cases of fair use. Starting with this video, I'm going to lay out what I think Sargon's legal arguments will be for his fair use case. As I said in the last video, there are four factors which fair use is judged by, and I'm going to be looking at all four. I'm going to be starting with what I think are the easiest arguments to make and working up to what I believe and what people online are generally accepting to be the crux of this case. Namely, whether or not the work is transformative. As I said in the last video, while this seems to be the most important issue in this case, it is important to understand that under copyright law, all four factors weigh in on a decision, and the extent to which a work needs to be deemed transformative will be determined by these other four factors. In other words, in order to decide whether the transformative threshold has been met, you first have to decide what it needs to be in this particular case. And to do that, you need to look at all the other factors first. With that in mind, the first thing I'm going to look at is Factor 2 of fair use law, the nature of the copyrighted work. In Nunez v. Carribean International News Corporation, the First Circuit Court of Appeals laid out these factors as follows. Courts have generally considered two aspects of the work in evaluating this factor. First, the extent to which it is a creative work enjoying broader copyright protection as opposed to a factual work requiring broader dissemination, and second, whether it is unpublished, in which case the right of first publication is implicated. So clearly the second of these two aspects is irrelevant. Sargon got the video off of YouTube, where the video was uploaded by Akilah and freely available to anyone that wished to view it. The work was therefore published, and this presents no extra burden on fair use. As to the first aspect, whether this is a creative work or a factual work, my impression from the wording of the complaint is that Akilah is going to try and argue that this is a creative work. Specifically this line from her complaint. Using this priceless material, Hughes created, edited, and published an original video essay detailing her unique viewpoint and sharing footage shot throughout this unforgettable night. However, a creative work within copyright law is generally considered to be a work of actual fiction, whereas this work centers around actual real-life event. And in Harper and Rowe v. Nation Enterprises, the Supreme Court stated in reference to a historic narrative or autobiography that the law generally recognizes a greater need to disseminate factual works than works of fiction or fantasy. The decision in Harper does, however, go on to clarify that even in factual works, there are gradations as to the relative proportion of fact and fancy. In copyright law, this is generally called the fact-expression dichotomy or the idea-expression dichotomy. And in the Harper decision, the Supreme Court found that the plaintiff had used the most expressive elements of the work, and this weighed against the fair use defense. That may seem to be a deciding factor in this case as well, except for one thing. Sargon's video wasn't making a comment about the events that Akilah was commenting on and trying to appropriate her unique expression of that commentary. Sargon's video was a comment on Akilah herself. In copyright law, the fact-expression dichotomy is the embodiment of a balance between the property rights protection of copyright law and the public interest in the dissemination of information protected by the First Amendment. Therefore, the greater the public interest in disseminating the information, the less weight is given to barring a fair use defense. Consider it like this. On one hand, you have a person that goes to a Broadway play, secretly records it, and then puts the recording online. On the other hand, you have a person that goes to a private event where a public official is talking to donors, secretly records the talk, and again puts the recording online. In both cases, the unique expression of the people being recorded is protected by copyright. However, the public interest of being aware of what the public official had said creates a much smaller burden in arguing fair use. In Akilah's complaint, she goes out of her way to explain how important she and her video are. Direct quotes for the complaint include, Hughes is a popular content creator and filmmaker. She has received many accolades as a social influencer, with her content and work having been featured in various media publications, including Fusion, Hello Giggles, Femsplain, and Refinery 29. On the date of the filing of this complaint, Hughes' YouTube channel has 155,223 subscribers, and her videos enjoy a total of over 10 million views. In addition to her YouTube audience, Hughes has built up an extensive following on Twitter where she has approximately 114,000 followers. In regards to the event in her video, it says, attending with press credentials, which she notes in her video were very hard to get, implying her importance in getting them, Hughes filmed the unparalleled events firsthand. Using this priceless material, Hughes created, edited, and published an original video essay detailing her unique viewpoint and sharing footage shot throughout this unforgettable night. Her video received immediate praise for its raw emotion and political commentary and quickly received overwhelming numbers of views and shares on social media. In her complaint, Akilah has made the case that she is an important figure and therefore her commentary on the election is worth taking note of. Therefore, while the expressive elements of her video do warrant copyright protection, that protection is considerably diminished against a fair use complaint by the public interest in knowing about her comments, including the way in which she expressed them. This fact is in no way reduced by the fact that she had already published the video on YouTube. The public interest in dissemination of information doesn't suddenly disappear once that information has been made public from a single source. That would be completely counter to the very idea of dissemination. This argument is further bolstered by the fact that Sargon's video excludes almost all footage taken at the convention. His entire video focused on Akilah's lack of awareness in her view of the world. Her attitude toward the people who voted for Trump was the thing being commented on, and this includes the way with which she expressed that attitude. Therefore, the expressive elements of her work, as well as her commentary, were the facts being commented on and could not be excluded from the video. I understand that Akilah's lawyers will argue it differently. However, court decisions have routinely made it clear that in cases of criticism, parody, and satire, that accurately identifying the actual target of the criticism, parody, or satire is critical to the question of fair use. In Dr. Seuss Enterprises v. Penguin Books, the Ninth Circuit Court of Appeals found that The Cat Not in the Hat was not granted the fair use exception as parody because its target was O.J. Simpson and not Dr. Seuss's style, stating, although The Cat Not in the Hat does broadly mimic Dr. Seuss's characteristic style, it does not hold his style up to ridicule. The stanzas have no critical bearing on the substance or style of The Cat in the Hat. Conversely, in Mattel v. Walking Mount Productions, Mattel tried to claim that despite Forsyth's, the artist in this case, claim that he was intending to ridicule Barbie, a reasonable jury could conclude that wasn't actually his target. The Ninth Circuit Court dismissed this argument, saying that even if only loosely, and not solely, Barbie was the target of criticism in that case. In this case, I can't find any argument to make the claim that the target of Sargon's video was anyone other than Akilah herself, and specifically the comments she made in this video and how she expressed them. Therefore, using her comments as made by her, including how she expressed them, was relevant to the criticism. That being said, feel free to tell me what you think in the comments below. Do you think that the target of Sargon's video was someone other than Akilah herself? Has this video changed your mind at all about Sargon's case? And as I've said in the previous videos, this is a brand new channel, and that means these videos making the legal case for Sargon aren't going to show up in anybody's feed. Obviously, Sargon can't comment on this case too much for legal reasons, and there's a lot of bad information out there that's damaging his reputation. If you think I make a good argument and want to help spread the word, click the subscribe button and share these videos on social media. Thanks for your help, and I'll see you in the next video where I cover commercial versus nonprofit use.